He looking all stupid.
Okay, look, I don't know who you are, Life 3, but you're about to be kicked out of the courtroom.
I apologize, Judge Simpson.
Who are you?
Nathan Mason.
Got her. Okay, I don't want to ever hear that in my courtroom about anybody.
I apologize.
I don't know if that's going to be good enough, but I'll get you when you get to your case. Mute.
This is where the courtroom shifts from minor chaos to total confusion. The judge attempts to transition smoothly into the scheduled case, but instantly hits a wall. Missing reports, unclear timelines, and a defendant who believes a 60-page handwritten document proves psychological competency. And here's the thing, courts don't evaluate competency based on page count. They evaluate based on comprehension, coherence, and ability to participate in a legal defense. So while Jason thinks he's proving stability, the court is only seeing more red flags. What makes this moment so fascinating is the disconnect between perception and reality. From Jason's perspective, he's showing effort. From the court's perspective, he's demonstrating why a competency review might be necessary. This kind of misunderstanding creates perfect on-camera drama and is exactly why so many courtroom videos go viral. You can't script this level of unfiltered human behavior. What do you think? Does a long written document prove competence or highlight the opposite?
Case People versus Jason Maples. Hey, what are we doing on this?
This was a show, except for a show cause that neither me or Schnauzer got the community corrections report, but he's also set to get a competency review. So I'm not sure we can do a show cause at this moment.
May I speak? Here's 60.
Mr. Maples.
Yeah, I wrote 60 pages for my trial so far. I mean, that doesn't show that I'm competent.
Your Honor, you can if we can adjourn it 1 week or two, I can.
When is his competency hearing?
In August 1st. August 1st.
Or 4th, I'm sorry, probably. August 4th. Hold on one moment. Let me see what I wrote.
Is there any way you guys can do an exception for me to go to the law library? Because what you guys keep saying I'm not competent, I can't go to the law library and study the thing, because once I am proven competent, I'm going to represent myself. So in the meantime, I have lawyers that are not coming.
I have August the 11th as well, Your Honor.
All right. Set a show cause for August 11th, 2022, 9 a.m. I will also, I can't set a preliminary examination, so it's just a show cause that'll be set for that time at the same time as.
Here, where the courtroom dynamic becomes almost surreal. The judge tries to wrap this portion cleanly, but the defendant's logic is spiraling. He believes writing a long document should override a scheduled competency exam, a misunderstanding courts see more often than you'd expect. Competency isn't about knowledge, it's about mental capacity to understand the process and participate meaningfully. What's striking is the judge's patience. They keep the bond as is, maintain structure, and continue following protocol despite the defendant's unintentional derailments. This moment highlights how courts must balance fairness, legality, and empathy even when the defendant doesn't fully grasp the process. And for viewers at home, it's a perfect example of how courtroom procedures protect defendants from themselves, even when those defendants believe they don't need help.
Case of the People versus Nathan Mason. That's the one.
Good afternoon, Your Honor. Alexander on behalf of the people.
Ready again, Judge. Torshell Feaster, Assistant Public Defender on behalf of Ms. Mason. Ms. Mason, please unmute and state your name for the record. Ms. Mason, please unmute and state your name for the record.
Had a whole lot to say before.
Ms. Mason, we're ready for court now. Would you please unmute and state your name for the record?
I already got in trouble because I thought I was muted and I wasn't. And this guy, he was calling this guy name. He was sitting there looking crazy. So I was like, he's looking off.
Ms. Mason, we got.
But I didn't know harm.
Ms. Mason, will you state your name? State your name for the record, please.
Nathan Lee Mason.
Thank you, Jim.
Ms. Mason finally unmutes after being asked repeatedly, and after initially almost being removed from court. This moment is a classic example of how virtual courtrooms create a whole new layer of chaos. Delays, audio issues, accidental insults, all things that rarely happen in a physical courtroom now happening daily on Zoom. What's powerful here is the judge's restraint. They maintain composure while the defendant rambles, offers explanations no one asked for, and reveals unnecessary details. But this also shows a key legal principle. In court, less is more. The more a defendant talks, especially unprompted, the more they risk hurting their own case. Watching this unfold, you can almost feel the public defender's stress level rising. And the big question becomes, does this defendant understand the gravity of the situation, or is she unintentionally creating bigger problems for herself?
Pre-trial in this matter. I've spoken to Ms. Mason and to the prosecutor's office.
How'd that go? No, go ahead. Anyway.
It's been rough, Judge. At this time, there are no offers on this file. If we could adjourn this matter, Your Honor, so we can hopefully get an offer, and if not, move it forward in another way to resolve it, Judge.
But could I just, may I say something?
No. What do you want? No.
I was ordered to pay $180, but I don't have an income because I'm disabled now. So I was trying to explain to him that I talked to a court clerk at 14A District Court. I called the bus back up there and talked to her and told her my situation. She said I could make a payment plan, but they never sent me through the mail.
Ms. Mason, is that this?
Yes.
Because if that's not this case,
excuse me,
is that on this file? Because if it's not on this case, Judge Simpson cannot do anything about that today.
Well, which case is this? It got to be the one I went to. It got to be the one that I already got ruled on because is it a case from that I had a bench warrant on? It was a warrant out for me on this case because I didn't pay $180.
Okay, you never had a bench warrant on this one. Me? You never had a bench warrant on this one.
Is this the one where I had the crack pipe, the paraphernalia, and I got caught stealing from Myers?
No, this is the one where you were stealing from the store, allegedly.
Right, from Myers.
This entire exchange is a masterclass in confusion. Miss Mason is genuinely trying to understand her situation, but she's mixing up multiple cases, dates, fines, warrants, and charges. Courts see this often. When defendants have several overlapping cases, it becomes extremely easy for them to confuse which paperwork belongs to which incident. The judge and attorneys are doing everything they can to clarify, but Miss Mason keeps introducing new issues mid-sentence. Crackpipe charges, payment plans, clerks from other courts, unrelated warrants. It's a tangle of topics that have nothing to do with the case being discussed. This is why attorneys stress staying quiet unless prompted. Clarity saves lives in court. Watching this, you can't help but wonder, is she overwhelmed or just not listening? And how likely is she to accidentally incriminate herself without realizing it?
And that's the one that you ruled on.
No, this is Myers. This is Meyer.
That's what I know.
You were stealing stuff.
That's the one that
allegedly. This has nothing to do with the crack pipe. That might have happened before or after. It has nothing to do with that.
It happened at the same time, Judge. It happened
well,
at the
I don't
same
know
time.
that.
You gave me 180-day rule, and you gave me a
Miss Mason.
$80.
Miss Mason, anything you say can be used against you.
But
so would you please stop until we can try to get this matter resolved, and we can deal with all that stuff at a different time?
Okay. So I don't want to go to no trial. What's going to take place now?
Okay. I was just going to adjourn it out so that everybody could talk to each other about it and get it. So I'm adjourning it to July 6th.
Thank you, Judge Simple. Thank you, sir.
Thank you.
This transition is one of the most unintentionally hilarious moments of the entire hearing. The judge tries to adjourn cleanly, Miss Mason tries to ask about warrants, and somehow the conversation nearly leads her into requesting one. This happens when panic overrides logic, defendants get nervous, start talking too much, and suddenly they're digging a hole they never needed to be in. This moment shows exactly why public defenders constantly remind clients to stop volunteering information. When the court isn't asking, don't answer. When the court is asking, answer only that question. Miss Mason's instinct to overshare is completely understandable. She's stressed, confused, and trying to get ahead of the issue, but it highlights why structure is so crucial in legal hearings. One stray sentence can change everything.
Eileen Mason.
Caitlin Kirby on behalf of the people.
Assistant Public Defender Melissa Kleeman on behalf of Miss Mason. And ma'am, can you unmute and state your name for the record, please?
We do not have her checked in.
I have had contact with her. I would ask the court for an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond 5,000, 10%. That warrant will issue on the 8th.
Excuse me.
Okay.
Hello?
Hello, who are you?
Hi, this is Natalie Mason, but my phone keeps messing up, Judge Simpson. So I just wanted to know, did you call my name yet? It keeps like going out and then coming
Okay,
back
so
in.
you can't just interrupt the court. No, I didn't call your name.
Okay,
So-
thank you.
We did call his name. Hold on.
Yes, we did call it, Your Honor.
Court recalls the case, People versus Nathan Mason. I will cancel the warrant.
Thank you, Jesus.
Caitlin Kirby on behalf of the people.
No, it's
The plea portion that follows is actually one of the most important legal moments of the entire recording. The judge must ensure the defendant understands the charge, admits to every element, and enters the plea willingly. And to Miss Mason's credit, despite all the earlier confusion, she does clearly acknowledge the facts. She concealed merchandise, attempted to leave, was stopped by loss prevention, and the value exceeded the legal threshold. What's interesting is the contrast between her earlier chaotic explanations and her clear responses during the plea. This structured format keeps defendants focused and prevents confusion. But the tension returns the moment she starts adding extra commentary, because every unscripted word could unintentionally complicate the plea. This moment is a great example of how fragile a plea deal can be when a defendant talks more than necessary.
anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense?
I'm guilty.
April 17, 2021, at the location of 3825 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, that being the Meyer store.
I know.
What did you do?
Went in and concealed several items into some bags and attempted to exit the store. I was stopped by, I guess, loss prevention.
Okay.
Stopped me on my way out the door.
Okay, and the items that the store was open to the public at the time, wasn't it?
Yes.
Okay. These items that you took, these were items that were offered for sale by Meyer?
Yes, sir.
And you didn't have anybody's permission to take that property, did you?
No, sir.
And the total amount of the property that you took, was that in excess of $200?
I believe it was four something. He said $400 or something dollars. I'm not sure.
So that would be more than 200, correct?
Yes, sir.
All right, counsel, have I complied with the court rule and would it be proper to defendant's guilty to this charge? Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be August 10th, 2022, 9 a.m.
August 10th, 2022 at 9. Okay.
Yes, that's when you got to come back and see me, but you got to see probation before that.
Okay. Yes, sir.
All right. Thank you.
Thank you. So, Judge, since I'm not going to have a warrant, Emma.
Why, you want me to give you one?
This case wraps with a scheduled sentencing date and a clear warning. Miss Mason must meet with probation before returning to court. Her plea has been accepted, the process is now in motion, and the next hearing will determine her punishment. What makes this case so captivating is the mix of unfiltered honesty, confusion, over-explaining, and courtroom patience. The judge consistently kept the proceedings organized despite interruptions, misunderstandings, and unexpected commentary, a testament to the structure of the justice system. This recording highlights an important lesson. Staying calm, listening carefully, and speaking only when necessary can make all the difference in court. Ms. Mason's case shows how easily a simple hearing can spiral into chaos when emotions take over. But it also demonstrates how judges and attorneys work to guide defendants toward the best possible outcome. If you found this courtroom breakdown as wild and unbelievable as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom moments and in-depth legal breakdowns. Your support helps us continue bringing these unbelievable cases straight to your screen.